He's a private attorney, and that was just within the last couple of days, and he did not get the order in time.
Okay.
So even though we brought you here, the new attorney I appointed for you was not able to be here.
Okay.
So what I'm going to do is just go ahead and consider you entering a denial to the allegations of violating your probation, and then set you on another day so you can talk to your lawyer, okay?
Okay.
All right, so let's get another court date for Mr. Hudson. Probably need to put him on March 18th. All right, March 18th. And Mr. Cobb has been notified. He was in contact with my office this morning when he got the email, but he just wasn't aware he had been appointed
Okay, yes, ma'am.
for you in time,
Yes,
but
ma'am.
he'll be out to see you, I'm sure.
Yes, ma'am, thank you.
Thank you.
Mr. Medina, are you ready for this?
Yes, sir. They will need to, if Mr. Gates is ready first, that would be advantageous, because I do need to, I've discussed, but they still need to read.
I heard you say you haven't spoken to him quite yet.
I'm good. You
Sure.
can bring him.
Yeah.
Okay.
As long as the court gives me a little leeway on Mr. Gafford, we're good.
Sure.
Beg your pardon. Sir, do you mind sending this back? I've already, they're ready to go there.
Not a problem. Okay.
Also, while we're waiting, remember yesterday we mentioned people being held in the jail waiting for rehab, like Phoenix House? I found the name of, or the information on the gentleman that may have still been waiting on a bed, and I've got that. I don't know whose case it is. Last name of K, would that be Mr. Gates?
K-A-Y?
No, starting with the letter K.
Yes, ma'am. That would not be me. Travis, do you have letter K? Do you have letter K?
Sorry, we'll bring it up later.
On the new case? On anything? On the new case, you
I know I had one
6
from
months or so?
like
And the older stuff.
November or December, and I'm hoping
And all
he's
that's
not there
been
anymore. We would have been hearing about it.
We're looking at
So,
about 6 months to
Yeah.
but he was the letter A or B.
What was the name, Your Honor? I haven't had anybody send this Phoenix House in a very long time, so I'll
Oh, okay, well, I can look it up. The last name was Knight with a K?
are they still in custody, Your Honor?
I checked the jail within the last day or two, and apparently still there. But it's okay, I can pull up and see who the attorney was.
Deontay Knight.
That's it. I just wanted to make sure he made it to Phoenix House.
He still show open.
Hmm.
It looks like it's Mr. Harper, Your Honor.
Ah, thank you.
Uh,
Thank you for that.
The case was reopened because he filed a motion to compel.
Right, because I think he's still in the, might still be in the jail.
What it does appear, and
It was a bars.
Phoenix House, he's been in since August on Phoenix household.
Yeah, so what's up with Phoenix House?
Your Honor, this is something we've found out, but apparently Phoenix House will not transport until probation files some sort of paperwork for the program. And that's been the hiccup that we've had. We've had a couple where Phoenix House basically is saying probation has to file some sort of form.
Okay.
I'm sure. Okay. Deontay Knight. And I don't know what, I can't remember what form it was, but we had this conversation in my office last week. And our investigator had a couple where, and I think Mr. Medina had one, where they weren't transported, and when we reached out to Phoenix House, we were told probation hadn't filed some sort of form.
It was a misunderstanding. They had, Phoenix House has had some turnover, and they were not aware that they had issued a letter of acceptance for somebody. So we just, there were some machinations to send them their own letter.
And I think that's, the hiccup is somewhere in between probation and Phoenix House. I think we're good on our side, so.
Okay.
Officer Prophet will take care of that, Your Honor, now that the court's provided that information.
Sure. Actually, the case numbers, in case anybody needs them, are 23 CF 704 and 23 CF 1515. And this gentleman is still in the jail waiting for Phoenix House, so I don't expect anybody to solve it right now in this court hearing. I'm just trying to make sure he gets where he needs to go or see what we need to do to get him there. Thank you.
Yes, Your Honor. This is Mr. Gafford before the court in front of 05 CF 13, 05 CF 14, 05 CF 279, 24 CF 1863. And then the plea agreement we have is also going to incorporate 25 MN 148. That's in front of Judge Schlechter.
Okay.
Mr. Gafford has asked if he could address the court before signing the plea agreement.
Absolutely.
Okay, thank you. First, I would just like to say that I am sorry for coming back again and again, but I just have a quick question. Okay, I did 20 years mandatory in prison, and I've been out for about a year and a half, and I've been in jail about a year of that. This is my fourth violation for a dirty urine. I have a drug problem. And the last time they got me into Keaton, no other programs would accept me. So I got into Keaton, I was there 5 days, and they said, sir, you got violent crimes. You can't stay here, we're sorry, you're doing good. And they made me leave walking back to probation, and I reported, and I got another dirty urine, and I'm back again. Okay, there's no help for me anywhere. The state's not doing anything. Okay, now they offered me 12 years to kill the probation. I was on 15 years probation, but I'm signing a deal right now, which I'm happy, I thank my lawyer, for 60 months. Okay, but with all due respect, okay, I have a drug problem. Okay, right now in Mississippi, there's a drug program that I could go to, but I can't leave this state because I am on 15 years probation after doing 20 years in prison for some stuff that I did 20 years ago. Okay, if the state, if there's nowhere for me to go, he's tried to get me in everything. Mr. Gates has went above and beyond. I got a drug problem. My drug problem was created in prison. That happened in prison. Prison is not going to help me. I mean, you see all these scars on me? That's not what I want to do. I don't want to go back for 60 months. But if that's what it takes for me to get off probation so I can leave Florida, I'm going to sign this deal. But I just want to know, is there any other way that is that what it is? Does it have to be 60 months?
I don't make the deals, so that's an agreement the state, or it's an offer the state has made. So I'm not, I didn't make that deal.
It's okay, and I'm happy
Yeah.
with the deal, and I thank the state for even letting me do that. But I just hate to have to go back to prison because prison it didn't help me. It made me worse. But thank you, and God bless you all, and I appreciate the opportunity. I'm going to leave Florida this time. I'm going to sign this deal right here. And 2/18/21. Y'all have a nice day.
Right, I'm going to ask you some questions about that.
Thank you, Travis. You're good, man.
Now, does this deal also include 24 MM 3214? MM 3214, I have that down as a VOP.
All I can do is just leave Florida.
I just don't know if that is being resolved, or is that going to hold up Mr. Gafford?
Man,
They're looking, the court picked up another case that we may not have addressed in the plea agreement. And
for what?
the other misdemeanor case you had, she wants to make sure we address everything so that there's nothing holding you up when we get done here today.
Oh, yeah, I was going to add, she said I had a March 3rd court date for another, I only had one misdemeanor though.
Did you go on probation for that other one though?
Yeah.
We'll take care of that one too.
Okay, yeah. Thank you.
You wanna?
concurrent with.
Okay.
There's two I filed and
Two, there's a new law and then a VOP one. I've got 25 MM 148.
Correct.
24 MM3214?
Oh, yeah, that's me.
Are those the ones? Okay, good, all right.
3214, Your Honor?
Yes, 24 MM3214. That is a VOP.
And is that's a first-degree misdemeanor?
I did not look it up, but I will.
First degree misdemeanor battery.
Okay.
Touch or strike.
And then 25 MM148 is the new law.
So, revoke and terminate probation. If you give it like a week, I can tell you, because the jail will tell me.
You gonna come see me for that reason?
I'll make a note to email you or send you a copy of that. If you're good with that. Unless you're anything.
No, it's all right. I'll find out sooner or later.
What I would do is I'd give it like some week and then ask to see if it has calculation.
So I ain't got nothing over me.
Nope, that should address that as well. I may give the state to sign.
Hey, you drop this.
I appreciate that. Just did it concurrent. And I apologize if the court has trouble reading my handwriting.
It's okay.
And I may correct this portion right now.
And we did discuss earlier on, this would be a
Yes.
departure for the plea agreement. This takes care of everything, okay?
Thank you.
In the 25 MM148, that's the new law misdemeanor.
Yes,
Would-
ma'am.
Would the PD fee be 50 or 100?
It should be 50, Your Honor, I apologize
Oh,
for
that's
that.
okay. All right, sir, if you'll just raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. If you'll just state your name for me.
Jeremy Gafford.
All right, sir, in 2005 CF 13, 2005 CF 14, 2005 CF 279. Thank you. And 24 CF 1863, and in 24 MM 3214. In all of those cases, you are alleged to have violated your probation. And then in case 25 MM 148, you are charged with the offense of giving a false name to law enforcement, which is a first-degree misdemeanor. Have you had a chance to talk to your lawyer about the allegations you violated your probation in the cases that I listed, and also that new charge?
Yes, ma'am.
Right. Did you read and sign the plea agreement?
Yes, ma'am.
Is this your signature on the next to the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Understand you're giving up your right to have a trial in the new case, and also your right to have a contested hearing in all of the violation of probation cases?
Okay. Yes, ma'am.
Are you entering the plea freely and voluntarily?
I am.
Is anybody promising you anything that's not in your plea agreement?
No, ma'am.
Has anybody forced you or threatened you to make you enter the plea?
No, ma'am.
Are you happy with the services of your lawyer?
Absolutely.
That's great to hear. Have you had any drugs, alcohol, medication, anything in the last 24 hours that affects your ability to understand what you're doing today?
No, ma'am.
Are there any objections to the score sheet?
No, Your Honor.
Did you get a chance to look at it after Ms. Gaynor made the corrections?
Yes, Your Honor.
Okay,
The difference was roughly about 0.4 points total, so it wasn't a big
okay,
difference.
all right.
I have a question.
On the new law case, is there any DNA?
No, Your Honor.
I do find a sufficient factual basis based on my review of the arrest report. And Mr. Gafford, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
And to the state, I do see that this is a departure. Is this a legitimate uncoerced plea bargain?
Yes, Your Honor, this is a product of a legitimate uncoerced plea bargain.
Okay. All right, Mr. Gafford, are you admitting to the violation of your probation in case numbers 2005 CF 13, 2005 CF 14, 2005 CF 279, 24 CF 1863, and 24 MM 3214?
You admitting the violations in these cases?
And to this one too.
Whether you're pleading no contest.
Oh, yes, yeah, I admit to all of them.
Okay, and then are you entering a plea to one count of false identification to law enforcement in 25 MM 148?
Yes, ma'am.
How do you plead in that case?
Guilty.
No contest.
No contest, my bad. Sorry.
I accept your plea in 25 MM 148. I find it was freely and voluntarily entered, and I accept your admissions that you violated your probation in the other 5 cases that I listed a minute ago. And I find that that was freely and voluntarily given. And, sir, I'm going to adjudicate you in accordance with your plea agreement. So there will be an adjudication of guilt on the new law case, 25 MM 148. In fact, there'll be an adjudication of guilt on all counts in all cases. As to the following case numbers, the sentence is going to be pretty much the same. It's 2005 CF 13, 2005 CF 14, 2005 CF 279, and 24 CF 1863. In all of those cases, probation will be revoked and terminated. There will be a sentence to state prison for 60, that's 60 months, concurrent in all cases, with credit for all time served. And in 05 CF 13, the costs are $100 cost of prosecution, $150 public defender fee. And the other 3 CF cases, those will all have $100 cost of prosecution each, and then a $100 public defender fee. Then in 25 MM 148, that's the new law misdemeanor case, adjudication of guilt, 11 months, 29 days in the county jail, concurrent with the prison sentence in the felony cases, with credit for all time served. $270 in court costs, is that accurate? Okay. And a $50 public defender fee. In 24 MM 3214, Revoke and terminate probation. If there's not a prior adjudication of guilt, there is in that case now. 11 months, 29 days county jail, concurrent with all other cases and counts. Credit for time served, $100 cost of prosecution fee, and a $50 public defender fee. Did I cover all of the, oh, I'm sorry, all outstanding court costs and fines or fees will go to a lien? Did I cover all the terms and conditions in all the cases?
Yes, Your Honor, you did.
Okay. Sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I will appoint one for you. Good luck to you, sir.
Okay.
Thank you.
Your Honor, this is going to be Christopher.
Yes, Mr. Gates.
Sure.
Mr. Gates, we do have a question about the previous case. The credit for time served, that doesn't include his prior prison time. That's just his,
He has
Jim.
there is no DOC time on that because he was sentenced to 20 years and I think it's 05 CF 12. And then 15 years of probation consecutive on the 3 cases we just resolved.
thank you. Thank you. Good afternoon.
Yes, ma'am. Good afternoon.
Your Honor, this is Mr. Hensey before the court in 24 CF 389. At this time, we'd ask the court to let us enter a denial on the violation of probation. If we could schedule that for, if we can, March 13th. I don't know if the court has, I think the court has a miscellaneous afternoon after the arraignments.
Actually, I don't on that day because I'm the duty judge,
Okay.
and that's, I'll be in court all day.
Okay.
So that's the only time I'll be able to do
If we could do
injunctions.
the 20th, then, and if the case gets resolved on the 13th, then we can just do it then. Because he has a new felony case, which is 25 CF 240.
Is that set for
Arraignments on the 13th.
on March 13th?
Yes, Your Honor.
So were you wanting to set an evidentiary hearing or just a,
Status, Your Honor, without subpoenas.
oh, well, if you resolve the new law on that day, we can always resolve this VOP
That's
on the
my
same
intent.
time, even if it's not on the docket.
Yes, Your Honor.
So do you want me to, what day do you want to put the VOP on? Or do you want it to track with the new law?
If we could, but just for Madam Clerk, March 20th at 2:30, and then if we resolve it, it will come off the docket naturally.
Okay. March 20th at 2:30.
Yes, Your Honor.
Okay. And then this new law is March, it's already set for March 13th
Yes, Your Honor.
at 1:30. Okay,
Thank you, Your Honor.
thank you.
Good luck, Chris. I think that concludes my business before the court. You're good.
All right, thank you, Mr. Gates.
All right, thank you, Mr. Gates. All right, who would you like to call first, Mr. Medina?
Any of my clients, Your Honor, Bentley, Blythe, or Black, in any order.
All right.
1 second.
Yes, sir. And I
So
think
you wanna
that's,
skip- You want to skip Adams for now? Save him for last? 'Cause it-
Frank, what is Frank's, is it Frank?
Adams, yes.
Frank?
Mhm.
Oh, I didn't know he was in jail, because he's a,
He's in a wheelchair. So
yeah,
you wanna
he's,
skip first?
I didn't know he got picked up, because he's a restoration issue. So, okay, whatever's easiest, sir. And if he's ready to go in a wheelchair, we'll get him out here and find out. I did not know he was in custody, and I was looking for him, so that's not good. Because he's, got a lot of physical and other disability issues. The nature of the underlying case that he has to get restored on was like grabbing his mother's, shaking his mother's wheelchair, so
And this is 23 CF 2078.
Okay, so, Your Honor, may I inquire, I apologize, I did not know the nature of his, I did not know where he was. Can the Madam Clerk advise, is there a new law?
There is.
Or-
And it is 25 MM 301.
Wait, ma'am, one second.
Could you not talk, let me find out, okay?
I just want to
I know, I want to find out what the charge is in the misdemeanor court, okay?
It is one count of trespassing. There was a first appearance, it looks like on February 12th, and,
Does it?
or February 11th.
Was the trespass at your mother's house?
No, it's a gas station.
Okay, all right, sit down, okay?
I'm trying to-
Okay, all right.
Looks like there's another 25 MM 291 possibly. Okay, so it's 2 new misdemeanors.
Okay, and one's a trespass, and is there any way to do a global resolution? The problem is he can't take a plea, because he was already determined incompetent and not restored.
I'm not incompetent. I'm saying it could be. I'm the
I'm not judging, I'm just going with what the court record reflects, okay? I'm not.
I got 20 fractures. I broke my finger in jail
All right.
because 911. I've been in court 20 times.
Thank you,
I broke my
sir.
finger because 911 in jail. Is that a punishment?
So, Mr. Medina, I
No, no,
do
sir.
see, sir, going to have to calm down. So, Mr. Medina, I do see there was an order entered on April 29th on the issue that you raised.
Yes, Your Honor.
So,
And it's been difficult to get him restored. There now is a forensic officer who could go see him at the jail and advise as to whether basically jail facilities would be able to handle that issue. If they're not, the court may have to consider another option.
okay,
So I can, if we want to continue, just enter well, there's really nothing to enter in this court. It's because or is it a VOP?
it says status call date.
Yes, that's right, because basically this was set about maybe like 2 or 3 months ago by Judge Ketchel, because we just needed to keep track of things. So unfortunately, he's in custody, but I will reach out to the forensic officer and have her go see him if she can. And could we just have this I don't want to say just like 2 days, but earlier as we can in March.
Okay, and I'm looking at this order. This was entered on April 29th, 2024, and Judge Ketchel made some findings and modified the stipulated bond to require Mr. Adams to remain in weekly contact with John Barnes, Okaloosa County Forensic Services, by phone or in person, and cooperate in development and implementation of an outpatient plan. So that was from April 2024. Perhaps Mr. Barnes might be able to enlighten us.
Well, I could give insight on
Okay.
that, Your Honor, myself. I think Mr. Barnes was already about out the door, substantial part of that period.
Okay.
So I think there would have been a new officer, and then she was going through various training and so forth. So she's only been really readily available for a couple of months maybe. So I would not hold that entire period as to being a willful noncompliance, even assume he's capable of anything willful. His brother is my only point of contact, and I did recently try to reach out to Michael, his brother, and was not able to reach him.
We're both U.S. veterans.
Okay.
How would you charge?
The problem is he can't take a plea, but
Right.
I've always felt that the state might want to exercise its judgment on the underlying case involving his mother's wheelchair being shaken. Grabbed the victim's wheelchair where she was seated and shook it multiple times by the handles. I'm not suggesting that that's not something the state could consider going forward with, but it seems to be a shame to me.
Maybe somebody came, I just
So,
went on that, I checked the
yeah.
wheelchair, that was enough for him to arrest it. But I want
So,
to say one sentence before. I
just-
don't care
just
what
one
that
second.
is. One sentence, Your Honor.
So-
One sentence, please, Your Honor.
One sentence.
Okay, my dad is a U.S. Army veteran, 27 years. His life was total hell. The sheriff's department gave him 20 DUIs when he moved out here for drinking sick time, once a month. So he never had to pay me because they paid lawyer. He worked American security, he can bring it. He can rest
Thank
in
you.
peace now that you know.
Yes.
And the world knows what happened to him. He
Thank
never
you.
had to pay you. You had
Thank
Army
you.
veteran, 27 years dead, no man.
Thank you, sir. All right, sir, that was more than one sentence, but thank you. Okay.
I'll kill that means you do whatever you want.
All right, thank you. Just let me look at,
I wish you look at it.
thank you. Let's just look at the paperwork, okay?
I move up.
So,
Sorry.
Mr. Medina,
Yeah.
I'm thinking another evaluation might be in order.
I don't think he's any, well, may I approach or, okay.
Yes.
Can I?
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
So, Your Honor, could we continue this to March, earliest possible date? In the meantime, an officer of the Okaloosa County will be going to talk to him.
Sure. Let's, I'm really getting worried about this March 18th date. How packed is it?
It's too bad.
Okay. March 18th. So someone will be covering for me that day. I will leave notes, but you may have to refresh them. If we need to bring the case in sooner, you just reach out, let my office know, we'll make it happen.
Why don't you find me $1,000 to get it over with? Can you do that? Can you just find me $1,000 and get it over with? Instead of this is going
Good
on
luck
for
to you,
2
sir.
years. We touched my mom's wheelchair. I broke my thing in jail. I've been in jail 5 months the last 2 years.
Goodness.
Touching her
Thank you, Your Honor.
Can't
Thank
you
you.
just
Thank
please
you.
find me $1,000 and get it over with, please?
So we'll call it a
Thank you.
status for March 18th at 9 a.m.
Competency status,
Can you
yes.
do that then, please?
So, thank you, March 18th at 9.
Thank you.
All right, and I do show an out-of-custody Haley Barnard.
Yes, I did call for her. I don't see her. I didn't see her this morning.
22 CF 2083 while we're bringing out the next, well, I guess we can deal with that later. We can bring on out the next inmate and then we can deal
There were
with that
one
at
or
the
two
end.
others as well that I
Okay,
didn't have.
we'll deal with them at the end. Okay, so whoever,
Bentley?
yes. 24 CF 159.
Your Honor, I do need to tell him a response from the state to an inquiry. Mr. Bentley wants to have a word with the court. I have advised him the state's best offer is 11 months, 29 jail. And he has a loitering and prowling that's the sole basis for the VOP. I've advised him that basically he's told me he wanted to fight that charge, and so we could enter denial, and you can see how that turns out. And unless the state has a VOP evidentiary with an underlying loitering and prowling, probably things would hinge on the outcome of that misdemeanor case. But he doesn't wish to take the 1129 offer from the state, and I have no way of making the state make him a better offer. He does, according to the state score sheet, if the charge sticks, score 14 months prison, I think was the amount. Wasn't that it? Robert?
14, yes, 14.1.
With that predicate, if he wants to address the court, I mean, that's up to the court. I don't recommend it.
Okay, so today is a VOP arraignment, so to speak, so, sir?
It was concerning about the VOP. I was under the impression of getting 6 months. I have a year of probation. I violated for loitering and prowling, which I didn't really do. I was just trying to get off the docket.
I don't recommend you discuss your case.
I ain't discussing it. I ain't really do it. I was just trying to get off the docket. So I was under the impression that getting 6 months, I only have a year of probation.
Your Honor, he made an offer of 6 months. The state said no, 1129. Then I came back and said, well, how about 9 months? And the state said no to that as well. So,
I said, how about 9 months?
right.
So it looks like the plea to probation was entered on December 11th, 2024.
That's correct.
Yeah. And
The
the
rest-
the alleged violation occurred a month later on January 16th, 2025 is when that's alleged to have occurred. So, sir, you can either, well, I don't control the offers the state makes, and neither does Mr. Medina. The state makes the offers they want to make. It's up to them and their discretion. So if you don't like what the state is offering you, then you can discuss your options with Mr. Medina.
Yes, ma'am.
So, Mr. Medina, is your client entering a denial?
Yes.
Or does he wish to consider what's being offered for more time, or?
I'm certainly not going to pressure him to take a deal. I don't think he should take a deal when he doesn't want to take it. So I think we need to enter denial. He can go meet with his misdemeanor lawyer and see how that's going. And
okay,
we can put him on for March 20th or whatever date is more available to the court, and we can advise then the status.
March 18th at 9.
Thank you.
Yes. And so entering a denial then?
Yes, Your Honor.
Okay.
To enter denial without subpoenas, March 18th.
Okay.
Thank you.
Sure. All right, we have 3 motions.
Your Honor, I apologize. I need to pull these up.
That's
My
fine.
assistant hasn't. Did you? Yes, Judge.
Okay.
That's okay.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please.
Thank you for that information. So,
Your
good
Honor,
afternoon, sir. Yes, we're here in Mr. Bethune's case, 3 cases. Each one has a motion in limine. Those case numbers are 23 CF 2580, 23 CF 2581, and 23 CF 2582.
Your Honor, I advised that the state's working on this. Assistant State Attorney Gaynor has only been in this present position less than a month and a half, I think.
Yes.
And I know she's working diligently on the issues. As much as I would like to cooperate in general, I must respectfully object to a continuance. I know that the state seeks a continuance and hopes that we can work everything out by March 18th or something like that?
March 19th.
19th. Just for the record, I'm objecting because he's incarcerated, and these are issues that the state probably should have addressed a lot of them a long time ago, such as crime scene photographs. So.
Let me ask this. I'm looking at the age of the cases, and I understand you've been waiting on these items, and I completely understand that. If you were to get these items soon, how quickly would both sides be ready for trial? I'm just trying to figure out how much more needs to be done, and I know you need to see the documents and things before you can really answer that, but I just trying to figure out how close we are.
Your Honor, I have basically taken the major nuts and bolts depositions. There's a lot of amorphous DNA information. I can't tell what the state or FDLE is saying the DNA relates to, and there has to be a statistical element to DNA. So putting aside DNA type issues, the rest of it is kind of mostly bricks and mortar type stuff, I think. So I couldn't say we wouldn't need more depositions potentially, but very likely we wouldn't need any more depositions except on the DNA issue.
Okay, so I'm going to grant the state's request for continuance of the hearing on these motions because Ms. Gaynor did just move into the division. She has been working overtime trying to remedy this particular situation, and I have every faith that it'll be taken care of soon. In fact, we probably won't even need that court date because I believe the issues will be resolved prior to then, and then we'll still be on track for resolution of the cases next cycle. So,
Your Honor, could I make one other appeal to the court?
Yes.
We had an issue several months ago. I think it was, I'm not exactly sure the date, but basically when I filed an original round of motion to compel, there was also basically a bond was issued that allowed him to get out of jail. I know that he's back in, I think an ORV was entered and he got put back in jail, but I would respectfully, because we're so far into these cases, 23 cases, it's not his fault that there's been turnover at the state and that he doesn't have a lot of things that he should have. And so I would respectfully think that a GPS monitor could put in place that would deal with any issues of potential absconding. And I would ask for Ori Tennis for reinstatement of bond.
okay, well, hold on a minute and let me take a look at things. So I'm going to give the state a chance to respond whenever you're ready. I know you need to look at it.
The state would object to any modification of bond at this point. While the defendant was out on bond and these 23 CF 2582, 23 CF 2581, and 23 CF 2580. I do see 2 new law violations that have actually pled misdemeanors, 23 MM 4022 and 24 MM 4017. One was a trespass and one was resisting without violence. The defendant did plead to the court cost and was found adjudicated guilty on those. So based on the fact that he is committing new law violations twice while out on bond, the state believes that's a basis to keep his bond revoked at this point.
I didn't catch that. Thank you for that. What I was looking at was bond was modified in June of 2024. There was a motion for bond reduction. At that time, the bonds were all converted to signature bonds, pretrial services with GPS, and so there was a release on those terms and conditions, and then less than a month after that, there was an affidavit filed by pretrial that alleged failure to comply with the pretrial services supervision, including, I'm going to read them. This is what was failed to comply with, allegedly. Contact the pretrial office within 24 hours of release from jail and make weekly contacts on Wednesday each week in person to ensure that the equipment is in working order, charged properly, and not being tampered with, and for defendant to pay GPS fees. The defendant has continued to not fully charge his GPS unit since being released from custody. The defendant has failed to fully charge his GPS unit, which allowed the unit to go completely dead as of Thursday, July 4th, 2024 at 4:15 p.m. This noncompliance allows the defendant to move freely without being tracked over the course of 6 days and also prevents his GPS points from being recovered. The defendant has missed his last 2 in-person check-ins, Wednesday, July 3rd and Wednesday, July 10th. This defendant continues to disregard any instruction to fully charge his GPS unit and report to our office on his regular scheduled reporting day. All attempts to contact the defendant have failed. These continued violations are a direct violation of defendant's pretrial services agreement. So Judge Ketchel revoked bond and entered an order, and then I think there was one other thing. There was also a failure to appear at pretrial. That was on August 12th. So we've got a failure to appear also. On that date, Judge Ketchel issued a no bond capias. So not only was there a pretrial services violation and an order revoking bond based on that, but then there was a failure to appear at the August 12th, 2024 pretrial conference. There was a capias issued for that. So looks like the defendant was arrested on those warrants October 28th. So that's like a few months, 3 months, I believe more than 3 months of just not complying, not checking in, missing court date, just waiting to get arrested. So in light of that, the request is denied.
Your Honor, he's asking, can he address the court?
Sure, but I've ruled, but.
Okay.
The judge's ruled.
Okay, it's okay.
So,
Well, I just wanted to say, I had went in the hospital
when I got released from the hospital, on them dates, I took my release paper. I had heart trouble, but I took it to the pretrial release man. Okay, I was going down there every Wednesday. So when I took him my papers to show him why I didn't report those days, I showed him my paper. I said, you want to make a copy of these to know why I wasn't here?
Okay.
So he told me, he said, no, I don't need a copy of these. He said, nah, Mr. Bethune, to be honest with you, if it was left up to me, I wouldn't have you come see me. I would let you just call in and report every Wednesday.
Okay.
You know,
Well,
see, but I mean, it's...
If Mr. Medina, if he was in the hospital, then
If we get any,
If you
his
have
family wants to
documentation.
provide some documentation that I think might assist the court or in the state, then we'll file it.
if you have documentation he was in the hospital, and that would explain the things I just read from
Yes.
the court file a motion for rehearing. So
Yes, Judge,
I'll
if we
deny
can
this
get
without
that-
prejudice.
If we can get proof, we'll advise the court.
Yes,
Thank you.
and I will reconsider.
All right, thank you.
Sure, so let's see, did we set, this is March, did I say March 19th? March 19th, and we will say 1 o'clock.
Okay.
And I have every expectation that the matter will be resolved prior to then, so let's go ahead and make sure that we're on the April 14th, or 14th or 16th.
It looks like his court was canceled and he's not on the docket.
Let's put him on pretrial, so maybe 16th. We're going to go ahead and set pretrial in all three cases for April 16th.
Yes.
But I did set the March 19th at 1 o'clock for the motions. If those motions get resolved, somebody let Amanda know so that she can free up that spot on our, these are special set hearings on that day, so we can offer that spot to another case.
Yes, Your Honor, we'll
Okay.
advise, and hopefully we'll know some stuff, and we'll go from there. Thank you.
Sure. Next would be,
James Black.
right, okay, that'll be next.
Yes.
Mhm.
Yes. Your Honor, I neglected to point out, because he had made in good faith a DOC offer to the state, and the state is looking at that. I appreciate him reminding me of that so I could remind the state of that. So
Okay.
we'll hopefully have some information on that by March 18th too.
If you need to bring it in early for any reason, I'll
Right.
do whatever I can do to
Because
make
these
that
are-
happen.
There are some pretty beefy motion and limine issues, so that might help us get a resolution if we can simplify or reduce some of the charges and so forth.
Okay, so if you need to bring it in for a resolution, I will find time to do
Right,
that.
okay. Thank you.
Okay.
I'm sorry.
Sure. So we got March 19th at 1 o'clock for the motion hearing, which hopefully we will not still need. Then April 16th at 9 for pretrial on all three cases.
Just, I'm in there in court. Swimming against the current. You know, Steve Medina with James E. Black. And
Yes.
I need to find his agreement, Your Honor.
Sure.
I think this, you have Black, right?
This is 24 CF 1588.
Yes, Judge, I'm just looking
No
for my
problem.
paperwork. I got
No problem.
sidetracked with, okay, that's Bentley. It is amazing how things wander off.
I can relate to that. I have a lot of papers
I
up
beg
here
your
too.
pardon, Judge.
No problem.
Oh, that's what happened, is I sent it back to, we only have
Yes,
one copy.
yes,
It
yes.
went
Okay.
back to Mr. Black. That
Right.
explains it. Thank you.
Sorry.
No, that's not his fault, because I actually talked to him before I sent it back, so let me make sure there were no questions. Your Honor, this is going to be a misdemeanor VOP
Okay.
agreement, and there will not be a score sheet, and I'm just making a picture. I
Okay.
apologize for
No.
my confusion. May I approach?
Of
Judge?
course, yes.
Oh, and he's signing it, and the state's
Yeah,
already
yeah.
signed.
Okay.
Thank you. Thank you.
Yeah.
Thank you, sir.
Mhm.
May I approach, Your Honor?
Yes. Thank you
Thank
so
you.
much.
Thank you. Your Honor, he was previously adjudicated guilty, but it was on misdemeanors. He is going to be, under this agreement, admitting the violation, revoke and terminate probation, 90 days Okaloosa County Jail. That's concurrent between the counts, and with credit for all time served. He represents to me, he thinks he has about a month and a half, but I can't tell him exactly how that's going to hash out. But it doesn't sound like he has to do a whole lot more to jail.
Okay.
$100 VOP, $150 public defender fees.
All right, sir, if you'll just raise your right hand.
Yes,
Do you
ma'am.
swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you. You can put your hand down
ma'am.
if you'll just state your name for me.
James Black.
Thank you. In case 24 CF 1588, it's alleged that you violated your probation. Have you had a chance to talk to your lawyer about those allegations?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, ma'am.
Is that your signature on the back?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing and make the state prove those allegations
Yes,
against
ma'am.
you? Okay.
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Is anybody forcing you or threatening you to make you enter a plea?
No, ma'am.
Are you admitting to the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. It looks like there was a previous adjudication of guilt on both of the underlying charges. Probation will be revoked and terminated, and I'm sentencing you in accordance with your plea agreement to 90 days, that's
Right.
90 days in the Okaloosa County Jail with credit for all time served, and a $100 violation of probation fee and $150 cost of defense fee. That includes the application fee.
Yes, ma'am.
And, sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
Right, thank you.
Thank you.
Yes, sir. Okay.
You got to see, he did, he never mind. Thanks, sir.
William Blythe?
I didn't even score sheet. Well, it's restate modified.
It's just modified.
Let's just advise the court of, do you have a,
Good afternoon.
Good afternoon, Your Honor.
do you have your paperwork? Okay, thank you.
Yes, sir.
All right.
I'm sorry, just in case you wanted a ballpark idea or something. Sorry.
24 CF 589.
Yes, Judge, I'm just making sure I've got a copy here.
Sure.
May I approach, Your Honor?
Of course.
And it's a reinstate modified. so
Okay.
There's no score sheet. I know the court sometimes likes one, but
fine.
Ms. Gaynor is attempting to get some information on the score, I'm not sure.
His total sentencing points are 76.2, and lowest permissible sentence is 36.15. This is a reinstatement modified though to a bars to bed program, so.
Okay.
And Your Honor, under the agreement, basically, I think I had informed the court, I know I informed the state that even I had a misunderstanding. He actually doesn't have to register, but he is designated. And so that creates some issues of placement for inpatient treatment. But thankfully, it's a good program called Master's Touch of Pensacola that deals with some of our hard-to-place inmates, and they're willing to accept him. And under the agreement, it would be admit, previously adjudicated guilty, reinstate and modify to add a special condition of bars to bed, Master's Touch. And he did ask if that was a way to avoid bars to bed, but the state's not willing to do it without bars to bed. There's a 10-month program that I'm not sure if they have more than one program, but that's a 10-month program per the literature we have, so that is prescribed in the agreement. Complete original requirements, $100 VOP fee, $150 public defender fees.
So if we're reinstating and modifying, what would be the term of probation? Just successful completion?
It was an original 4 years that he took, less than a year ago. So he's got over 3 years, or right around 3 years left.
Okay, so
I think
this would
4
just...
years he took, right, concurrent?
And then the balance after completion of the program would just be on regular probation?
Yes, ma'am. He's definitely coming out to probation.
Okay.
See, this is the one you previously emailed us, right?
Yes, ma'am. Yes, ma'am. I did email the court, and then I emailed, I think I emailed you some more.
Yeah, no, it was I don't know if it was him or Mr. Judge.
Your Honor, he's mentioning, we've had this come up before, and basically, Master's Touch, for all the benefit of their program, they don't provide pickup.
Oh, yeah, so how's he gonna get there?
And he has to also, before he goes to Master's Touch, go to 13 Kelly Avenue, Fort Walton Beach to touch base on the reinstatement. I don't know the answer to his transportation. With the 1 or 2 times we've had this to happen, there's always somebody, family, who can kind of swoop in and help. I don't think he has anybody who can help him, and I don't have an answer to that. I know, I mean, we are not allowed to provide transportation to the public defender's office.
Right. So, sir, what's your plan?
Well, ma'am, my sponsor, Michael from 52 Beale, could take me there, or my pastor could take me there. But I'm just curious on the nice lady at Master's Touch said that she's epileptic and she does not provide transportation. So I was really concerned about how I would be able to do that if you guys are requiring, and I don't have a way to get out and call, like, you know, hey, Mike, listen, I'm my sponsor and all, can you please give me a ride to, you know, to Master's Touch in Pensacola? Here's the address.
Your Honor, the public defender has a experienced investigator who can touch base with Master Touch. She's really facilitated his quick turnaround on an interview, so I can ask investigator Tejan to reach out to them and tell him he's pled out today, but that still doesn't, you know, you're still going to have transportation to probation and then to Pensacola.
And then if it's my question also was, if it's a bars to bed, I'm supposed to go from jail to the bed. How do I get to Fort Walton?
I'm sure probation has a way they work.
I mean, is there a way that I could go to Pensacola and Escambia County probation and check in with them instead of coming all the way back to Fort Walton? So I really don't want to go back to Fort Walton.
What do they, yeah, how do they get bars to bed if they have to check in along the way?
And that's the issue. Normally, the provider picks you up, and I'm not too familiar with the Master's Touch from Pensacola, but other Master Touches have picked up from the county jail to transfer.
Well, this one is not, and.
She's epileptic, so she doesn't drive. But like I said, it might
And
be
I don't know the
responsible.
workaround, other than that we've,
But
it's like a
Master's Touch is what it is? Yes, sir, it's in Pensacola off of Mockingbird Lane.
So ordinarily, if, let's say, the program did pick up, they would pick someone up and then take them by probation first, and then they would, okay.
right, and
Gotcha.
I've got, if, we probably don't want to call her from open court, but I've got their number. They're at 8432 Old Spanish Trail, Pensacola, Florida, 32514. And I've got the phone number here. And basically, my investigator has been texting me, and I know she'll do everything we can in good faith to try to coordinate. He's not going to be back to the jail to probably even get to Fort Walton Beach today. The court may want to order that the release not take place till tomorrow morning. Maybe we need to do that because I don't want him not knowing where to go tonight. But he can check in tomorrow at Fort Walton Beach and then get to Pensacola if he can get a ride.
Well,
but I don't know about the logistics of the bed, and you know it's we try to do these deals. This is
I
a
know.
difficult logistical question.
A bed open, he can't be released unless there's a bed open, you can go check in.
There's a bed open. She said she would leave the bed open for 15 days for me.
Yeah, we did get I mean, I have no reason to think there's not a bed, but this is beyond my logistical capabilities to provide
Right.
assurances.
Your Honor,
yes.
does the defendant, you said your sponsor,
Yes, ma'am.
will your sponsor pick you up from the county jail?
Yes, sir. I mean, if I could get a hold of him, I have his number. I actually don't have any time on my account. So
You need the name and everything for the jail, otherwise they won't release him.
Who is the name of your friend who would do the pickup?
His name is Michael Johnson. I believe his last name is Johnson. He is.
You don't know a number standing here, do you?
I'm not standing here. I do not, sir. No, sir.
Okay. So,
I mean,
What I propose to you,
if-
if we take a short break and try to come up with a plan to address the issue. I give it a little time, maybe we can make some emails and phone calls to try and get an answer. I've emailed our investigator, Ms. Tejan, to see if she has an idea of what we can do.
I'll certainly be texting her.
Another thing is that, if I may, their office is right across the street from 52 Beale. If I could go to Fort Walton, meet up with you guys in the morning, or, well, it'd have to be in the morning time, I guess. You know, Mike goes to the 8 o'clock meeting, he goes to, usually noon, but I can get down there, call him, meet up with him, probably at probation.
Well, let's work on figuring out your ride.
Yeah.
And then we can allow you to go directly to the office in Pensacola.
That would be wonderful.
Yeah, the plan is, there's not really a concrete plan right now. And if it's bars to bed, then unless we have a concrete plan, unless y'all have a concrete plan.
Text.
Okay,
The text is that he does have a bait available now
okay.
from my investigator. But I don't know how he's going to get to these. She says she's tried everything for transport, and she's reached out within the public defender to see if there's anything we can do, and there's nothing we can do to provide transport.
I'm sure that Master's Touch Ministries probably has had this problem come up before.
Oh, and we've had this
So they might have a
discussion in open court before,
Yeah.
and it's been about as successful as right now.
Oh.
It's just a tough.
Well, Master's Touch, you would think would have some alternatives or options or suggestions, but without a concrete plan, then you could just be sitting in jail stuck indefinitely because we're at a stalemate. So,
I would respectfully request that the sentence be imposed, if the court's willing to do it, because we very well may be working this out, but he can't go until the jail has, in probation, have confirmation that he has a bed. I know that Tatum Tejan could talk to, in probation, confirm that part. What I can't confirm is who's gonna drive him. He says maybe this Johnson person, but.
That's my sponsor.
And I just got word Master Storage Touch does not transport.
Oh, I know that. We've been discussing that for a
so
while.
you're not able to call your sponsor, is that the problem?
Yes, ma'am.
Thank you.
I could see him at a meeting, and I guarantee, or if I couldn't get him to do it, I've got Rick Van H at a meeting. I've got my friend Russ, who does Uber. He used to be a federal correction officer up in Georgia. I mean, I do have very responsible people. Ma'am, I just want to get to this program. I need help.
I understand that, and everybody, your lawyer is going above and beyond to try to get you in the program and get everything to work out. My goodness, the PD's office is practically like a, social welfare agency trying to help people and get them services. I've never seen such efforts made previously. So,
Your Honor.
I mean, he's just going to sit there, though, until there's a plan.
The other issue is it looks like his spot's only available for 14 days. So
That was why we needed to expedite it.
I mean, I'm not going to just sign off on something to let you out and then just leave you to your own devices to find your way to this
Your Honor,
place.
Here's a suggestion. Within the 14 days, would the court carry him over till jury review, day after tomorrow?
Yeah.
We'll try desperately to work something out, and the court could potentially impose sentence Thursday at 9 a.m.
I will be happy to, as long as there's a concrete plan to get him
Right. Well,
from the jail.
I'll get my investigator to rack his brain, and maybe we can find somebody who's willing to drive him. And that's all I know. We'll try.
I mean, do you have any family members that are in touch with you, somebody that can reach out or somebody that can transport you?
Like I said, I mean, if I can get back to get a phone call to my sponsor,
when he gets
sure
back
he
to
could
the
do it.
jail, just have your sponsor call our office and we'll coordinate that. It's the easiest thing we can do right now, is just when you back,
Okay.
you have at the jail, right?
Yeah.
Tatum Tejan, he doesn't have any minutes.
I don't have minutes. I don't have money. I don't have a way.
All right, well,
What we'll do.
Okay, we'll see you on Thursday.
here's
9
this
a.m.
thing, I'll give you this back. Thank you. We're resetting the case for Thursday morning. So, sir, that gives you a couple days to try to work something out to get you there, okay?
Yes, ma'am.
All right, sir.
That's February 20th, 9 o'clock.
Yes, ma'am. Thank you, Travis.
Thank you to all of you. All right, who is next on our list? Is that all of the inmates? Okay.